Hi, y'all, and welcome to tonight's live stream. Today was another huge day in the Karen Reed trial, the retrial. Digital forensics expert Jessica Hyde took the stand, and the stakes were very high because if the defense is right about when Jennifer McCabe Googled Haslam to die in cold, if it was at 2:27 a.m., then that means Jennifer McCabe probably had information that John O'Keefe was dying in the front lawn of 34 Fairview. But according to the Commonwealth, that's not when that search took place. It took place hours later, and Karen Reed was the one who asked for that search to be made. Hyde says the whole idea that it happened at 2:27 is just bad science. It's a misunderstanding of how the program works. So how solid is that claim? Can we trust the data? And is the defense expert totally wrong or just reading it differently? And what about that moment that everybody's talking about today when the defense wanted to show another judge's opinion to the witness, to Ms. Hyde, and Judge Canton ruled it out and said, you can't do that. Now, the defense wanted to be able to show that opinion to the jury. Judge Canton said, no, was that the right call? Should the jury have been allowed to know that in another courtroom, another judge said her forensic methods weren't reliable? Is that even what was said? And was it unrelated? We'll talk about it and about what that ruling might mean for the rest of the trial. Now, meanwhile, the taillight evidence made a huge return. The same red plastic pieces we saw at Karen Reed's first trial last year. But this time, the Commonwealth brought some of the worst information out on direct themselves. They tried to explain away those inconsistencies before the witness could get embarrassed by the cross-examination. So, yes, the badges were mislabeled. Yes, there were extra pieces no one can account for. But did the evidence have the same impact this time? What is this going to mean for Karen Reed's case? And then there is the bombshell that could still change everything, the step data from John O'Keefe's phone. The prosecution's own expert had to admit that John's phone kept counting steps until 12:32 a.m. Some kind of movement, steps, movement, something. But by then, Karen Reed was already home. So how was John O'Keefe still moving if he's already lying prone on the ground outside 34 Fairview? Does that prove he was alive when she left? Or does it mean someone else may have attacked him later inside 34 Fairview? That's what the defense says. There are so many questions, not always with clear answers, at least not yet. So we are going to break down day 11 of the Karen Reed retrial. Was it a win for the Commonwealth, a missed opportunity for the defense, or are some cracks really starting to show in the Commonwealth's case? So let's get into it. A few housekeeping matters. First of all, don't forget, if you're a member, we have our members only live right after this. I want to say a special shout out to the first 5 in tonight's chat: Oklahoma Gigi, Just a Girl, Camilla Juliana, Mr. Wu, and Shiro Shina. Welcome in to all of you. So let's talk about, and one other thing. I mentioned that I am going to be out of town, or I mentioned that I'm going to be off the air for about a week and a half. I am going to Iceland with my daughter. And so I am going to actually be talking about this case from Iceland. You can meet my daughter. We are going to be doing, I think, mostly in a members only format. We're going to be talking about what's happening in the trial. I'll show you Iceland. I've never been there. I'll show you what I find out. What is it really that cold? What about the volcanoes? What will we find out? So be sure to tune in if you're not a member. A lot of that is going to be on the member side. So, okay, let's pop into what we're going to be talking about tonight, which is the video. Let me get everything queued up. I'll go ahead and get it started. I've got so many windows open. Okay, here we go. There's this window. Okay. Let's add this one to the stage, and meanwhile, I'll be looking up what I need to say. It'll take just a second. So what you're seeing here is something that looked really different last time. Now, this is the witness, Trooper Keefe, showing the jury 2 pieces of red plastic taillight that he found in the front lawn there at 34 Fairview. Now, the Commonwealth says these are pieces of Karen Reed's taillight, that she hit John O'Keefe, it broke the taillight, and the pieces scattered around him. That's what this witness is saying. So what you're seeing, though, is really different from the way this came in at the first trial. Now, at the first trial, Lieutenant Tully talked about this, and the defense made it extremely dramatic. They pointed out all kinds of consistencies. One huge one, the bag was marked as having 2 pieces, but inside the bag were 3 pieces. So the witness in the first trial took out and said, okay, here are these 2 pieces. And the defense is like, well, what's this? And it just was incomprehensible as to how they could have missed that. This time, the prosecution had the huge advantage of knowing that there was a 3rd piece in there. What they say is it just broke off at some point in the handling, and maybe it was already even splintered. So what you're seeing is very different from the presentation of what happened last time. The prosecution, the Commonwealth, got a chance to deal with it first and to talk about it. So here's the way they did it. They initially said, okay, he pulled these out. He said, okay, here are 2 pieces, and here's a 3rd piece, and here, and they have stickers on them already. And we'll walk through what he said.
Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces, or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
So major drama last time over this piece, but you saw it here. It was just sort of blah. He just said, yes, here's a 3rd piece, and it may have broken off. Now, mind you, there is no evidence that that piece broke off in the bag. There's no credible evidence as to how exactly there are 3 pieces when there were supposed to be only 2. It's not clear at all. But the suggestion that it was broke off could definitely be the case. We just don't know because there's not actually any evidence about that. He'll talk a little bit more about that. By the way, would you mind hitting the like button? That'll really help us get the video out to more people. Would appreciate it if you would do that.
Small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. I'd like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit. You recognize that?
So that's a little bit unfair almost. Like, okay, now we're all worried about making sure the evidence is really secure and putting it in another bag. I mean, yes, that's exactly what should happen. But it isn't exactly fair either, because all of the drama of them not having done that the first time is sort of drained out of the trial. This is what I'm saying by telling you that every time you retry a case, it's a different case. And there are things that are really different about it. It never is exactly the same trial. Every single time there are surprises and things that just go differently. One huge difference is that both sides know the places where they lost or did poorly last time, and they have the chance to shore those up. That will be just as true for Karen Reed's side as for the Commonwealth. Maybe not quite just as true, because I think Karen Reed's team brought their A game last time, and I think the Commonwealth did not. So they maybe have a little bit more opportunity. Now, one of the things they did very clearly was something we talked about last night. They specified that it's really important that the Commonwealth says John O'Keefe was killed after midnight, just shortly after midnight, maybe half an hour or so, and there wasn't much snow on the ground then. So these pieces of taillight need to be on the ground, basically on the grass, and the snow should be on top of them. If instead they're on top, that lends some credibility to Karen Reed's claim that Trooper Proctor came and scattered them around on the ground just to frame her, that was his purpose in doing it. So this witness testified very clearly that at least two pieces he found on the ground, at ground level. Here's what he said.
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes.
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
We'll stop there. Now, the defense didn't do a lot with this witness. The primary point was that this witness attended the autopsy where the medical examiner ruled John O'Keefe's cause of death as undetermined, not a homicide. And that is true. We will hear about that again when the medical examiner actually testifies. It was a huge point for Karen Reed in the first trial and again, the second trial. Not just because of the fact that that's what the medical examiner ruled, but also because of the fact that the Trooper Proctor, pretty much admitted he tried to get her to change that. And there were even text messages back and forth where they talked about, wow, you weren't able to get her to change her mind. Wow, you're a terrible trooper. And as if that's a regular thing. And clearly that should not be the case. The medical examiner should be making the determination as to how the person died based on the medical evidence. Certainly some evidence of what people saw at the scene would be relevant, but that the role of the trooper is not to try to persuade and to create what the finding will be by the medical examiner. Neuropsych Zena says, please don't be scared of the like button. Yes, please don't. We have a very, very friendly like button here. So please do hit that like button. I guess that sounds unfriendly, doesn't it? But still, we would appreciate it. Lois Cox is a new member. Perfect timing because we are about to go into our members only right after this. We are writing a true crime novel and I am so excited about it. So we have some new twists and turns that will be introduced tonight that you will be introducing. So don't miss that. And of course, next week, there will be some more stuff straight from Iceland that will be in the members only category. Michael, yes, favorite color is red. Thank you. And thank you, Mitt Spunky, for gifting 5 lawyerly memberships. Again, perfect timing. I really appreciate that. All right. So there were many more, much more significant controversies over this next witness, digital forensic expert, Jessica Hyde. Now, the defense wanted to impeach her by showing the jury a judge's opinion in another state, in another case where she was not allowed to offer her opinions. The judge ultimately said that the defense could not use that information, could not use that opinion. So I want to talk about why not and whether that was a fair ruling. Now, the defense started by arguing that it should come in. This opinion should come in. They said, look, we've got a certified copy, which means it's competent evidence under the law. You can hear what the argument is.
Judicial proceedings of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Okay, how about that? That should be sound. Hopefully sound. Okay, sound. There we go. Sound, hopefully. Sound is here. Please tell me sound is here. Raised, muted. No one has had this many malfunctions on their phone. I have. I definitely have. Okay, there we go. We're back. We're back in session. Okay. So now what he's arguing here is that that I have a certified copy. I can prove this is really truly an opinion from another court. But that only gets him a little bit of the way. That just means, okay, this is actually the opinion. It doesn't mean it's relevant or that it has anything to do with this case. So this is just the beginning of an argument. It's not a whole argument. It's not enough to convince her. And the judge asked for that. Okay. So tell me more about, in her case, she thought it was, what he was trying to say was he wanted to keep this expert out entirely. And she's saying, okay, tell me what you want out and why. And so the next thing the defense went to was arguing that there are rules that say one court should take judicial notice of what happens in another court.
Which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable.
Now, again, that idea that there would be judicial notice, that just means a court is allowed to say, yep, that's what another court did. It can take judicial notice of it, can say, okay, as a court, I know this to be the case. You don't have to even submit evidence. But that doesn't mean it should come into the trial. You still have to decide whether it has anything to do with this case. So the judge asked them, focus on what you want. And so he tells her, okay, we want to put this in. But here's the thing. This was just a trial court opinion. Apparently, the witness submitted it from something she said. She submitted this pro hoc, which means just on her own, as an amicus brief. Some people call it amicus brief. So meaning that she did it not on behalf of either party. She just suddenly came into the case and said, this is my opinion. And in which case, it is no surprise that got eliminated from the case, because that's just not the way that things are typically done in court cases. She was not hired by the state, but apparently her opinions in that case did in fact favor the state side. The court excluded her testimony in that case for probably a host of reasons, because of the fact that she was not actually the main a witness hired by either party, but also because she had not used Apple source codes. And that did not sit well with Judge Canoni. Here's what happened next.
But there's two parts to that decision, two areas. It's FLH, frequent location history. Right. But what the court also got at was Apple source codes. That she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking.
What I want to do is, with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So here's what Alessi's saying. He's saying, I want to cross-examine her on this opinion because it says she doesn't use and doesn't have access to the Apple source codes. I'm just going to tip my hand. That is not how it works at all. I mean, first, you almost never get in an opinion in one case in another case. And the reason for you definitely use them all the time to make arguments to the court to say, Judge, other courts have ruled this way. You should rule this way also. But when it comes to the jury, the court wants to be sure that the jury makes the decision on its own, not based on what another judge said in another proceeding. So it would be very unusual to get to use an opinion in front of the jury because it might influence the jury. Well, this is what a judge somewhere thought. And you're free to argue that the expert used the wrong methodology. And in fact, they were allowed to do that here, but you can't use a court opinion for that. The opinion is very useful in a Daubert hearing. So when you're asking the court in your case, whether you're asking this court to say this witness is really not qualified to testify, Your Honor, and so I want you to exclude that entirely, then you easily can use opinions from other cases. That's a very normal thing to do. In fact, it's a huge problem for an expert witness if they get excluded in any case, because then that gets used in case after case after case. And as we've talked about on other lives, one of the things that experts they do this as a regular business. This is their business. It's where they make their money. And so getting excluded in any one case can be a huge problem for them. But in this particular case, you don't normally use the opinion to cross-examine. You use the opinion to try to convince your judge that this expert witness should not be used at all, is not a witness who is appropriate, or maybe some of their opinions should be excluded. Maybe not every single opinion, but some of them. And you say this other judge did that. But once the judge makes a determination that, no, this is an expert witness, and this person does have qualified testimony on this subject, then at that point, the opinion is not really important. It was related to another case and to what was said in another opinion. Now, the Commonwealth objects. They make a pretty decent argument. I'll play that for you, and then we'll talk a little more.
An attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court.
So the judge is still trying to figure out at this point why this would ever come in her case. And she points out, well, defense, you didn't try to use this when Ian Whiffen testified. And Ian Whiffen also testified that the Hoslon search by Jennifer McCabe was originally thought to be at 227, but that it really occurred later. It was misinterpreting the data that made everybody think it happened at 227. So here's the defense's next argument.
It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor,
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology.
So I disagree here, because once the expert has been admitted by the court, the judge has found that their testimony is appropriate to go to the jury. So now you are arguing to the jury the question of whether or not their methodology was reliable and whether or not what they did in the case was reliable. That maybe you're going to argue that the way they conducted their tests or the way they came to their conclusions was biased or wasn't based on science, but you can't argue the entire testimony is fundamentally flawed because some other court said so, because that wasn't this case. And in this case, the judge has already said this testimony comes in. And we're going to talk for just a minute about what this means. And I think some of you will be surprised.
And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on.
You can see the plan.
So, and certainly he can cross her on that, absolutely. But a trial court in another state is not an expert source on that subject. A trial court in another state is not an expert on whether you need the Apple source code to talk about what she's saying. You need an actual expert or an actual document or a source, not what another court said. So the other court itself is not an expert. The Commonwealth, though, jumped all over the way Alessi had phrased it, and he did backtrack on that.
To dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court?
On which she's going to testify in her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Daubertize anymore.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see.
So the main reason why I'm kind of making a deal of this and talking about it is I think that the judge was clearly correct here when she ultimately ruled, after going back, reading the opinion and thinking about it, when she ruled that they could not use this opinion in their cross-examination. They were free to cross-examine her on all of those issues, but not by using what a court wrote in this other case. And I think she clearly ruled correctly on that. Now, here's why I think this really matters. I know that I'm watched the chat scroll by as I'm watching the case. I know that a lot of people feel like Judge Canoni is highly biased, and I can't argue that she has ruled time and again in favor of the prosecution of the Commonwealth. But in this particular situation and in others, I think she usually takes a fairly measured approach. She goes back and thinks about it. She takes overnight. She waits a week. She takes some time to think through what she's going to rule. I don't think she is 100% the worst judge ever, and I don't think she's 100% biased against the defense. So I did want to point this out because I wanted you to understand why it is that I say that I don't think she's completely biased. I realize that is the popular opinion, but sometimes the popular opinion maybe needs to be rethought. And I especially think it's important here when we're talking about a judge. It really does matter. I know that if people believe a judge is being unfair to somebody, that does a lot for our belief about the justice system. And I'm the first to say that there are places and times that are extremely unfair, and that Judge Canoni has had a pretty heavy hand on the Commonwealth side of the scale. Like, yep, they're usually going to win. But I do think we also need to recognize when our completely one-sided view isn't quite fair. And I think this is a situation where that's the case. So that's why I make a big deal of it and talk about it. So let's talk. SN is a new member. Welcome. Thank you, Marlon, for your note about the audio. And Allie is a new member too. Now, Mr. Wu coming in again with SUVs don't leave dog bites. He is absolutely convinced about this, and we are hearing that over and over, and it's certainly the case. We are going to get into, in the next week, maybe, the battle over the dog bite or the scratch from the taillight. We are going to hear from experts from both sides. Karen Reed's team believes fully that the marks on John O'Keefe's arm were caused by a dog bite or dog scratches, and then the prosecution, the Commonwealth, is convinced that this was from the taillight. So we will hear what they have to say about it. Mildred Hornblower is very concerned, as she should be, about the really poor collection and preservation of evidence in this case. It is really frightening, and it's frightening because it has implications for fairness, not just to Karen Reed, but to other people. That audit done of the Canton Police Department showed us that. And the fact that Trooper Proctor was removed and there were other cases he was involved in, also very frightening. I mean, you have a definite good point, Mildred. Sue Bass is a new member. Welcome. And Michael Lalonde pointing out a big mistake in my discussion. I got a little too excited about, the legal side of things. What is a Daubert hearing? Very basic. I should have said that from the beginning. My apologies. And when he says she's Daubertized, what is he talking about? What is Alessi talking about? Well, we have reached a point in our legal system where we are heavily dependent on expert witnesses to explain things to the jury. To some extent, that's just normal and we can't escape that. That's because we have so much more scientific evidence now, and the jury can't possibly know the DNA evidence. They can't possibly know even things like fingerprinting. They can understand it, but they can't. They need somebody to explain what the evidence is and what it means. Cell phone evidence is another great example, but it has also reached a point where we have that in every case. It's very expensive, and it's more and more common that people need that on both sides. So it's raising the cost of things. Now, a Daubert hearing is the spot before the trial gets started when the parties come before the judge and they say, the other side wants to use this expert witness, and we don't think that expert witness is appropriate. Either they haven't done all the work they needed to do, or they aren't qualified, or what they have to say isn't relevant. There could be a lot of different reasons why you would say that. But it's called a Daubert hearing after a Supreme Court, United States Supreme Court case that talked about admitting expert testimony in court cases. And so it's called that. That's the kind of hearing it is, where you argue about the witnesses. In this case, Judge Canoni has ruled that these experts are allowed in. We covered on this channel some of the Daubert hearings related to the dog bite experts and so forth. These are very hard fought opinions, because if the testimony comes in, it can make a huge impact in the case. So Daubertized means that a judge somewhere during a Daubert hearing, I've never heard that phrase before, by the way, but Alessi used that. And I believe what he meant was this person has been, under the Daubert rule, held to be not competent to testify or not able to testify in a particular case. All right. So now, next, Jessica Hyde took the stand. The forensics expert who talked about the data that came from various phones. She looked at the cell phone data, and she testifies that Jen McCabe's Haas-Long search was not done at 2:27 in the morning, which is what the data would originally show. It was done at 6:24 in the morning. It makes all the difference, because if it was done at 2:27 in the morning while Jen McCabe was sitting in the comfort of her own bedroom, then Jen McCabe should have had no clue that John O'Keefe or anyone else was dying out in the cold. Why would that, what would cause someone to suddenly search that while they're in their warm bedroom at night in the middle of the night? Instead, she says the next morning after they looked for and then found John O'Keefe's body lying in the snow outside 34 Fairview, that's when she searched for that. And it was because Karen Reed asked her to, Jen, Google how long to die in the cold. And so she Googled that. But the data suggested when they did a Celebrite search that this search was done at a time it shouldn't have been, in the middle of the night, 2:27, not when the body was found after 6 a.m. So it's a huge question. If the Commonwealth is right that this was done at 6:24, well, then Jennifer McCabe's story about Karen Reed asking her to Google it is possible. But if it was searched at 2:27, Jim McCabe has a lot of explaining to do, because there's no clear explanation for why anyone would do that. It makes no sense. So this witness is here to talk about how you know whether the search was done at 2:27 or done at 6:24 in the morning. How do you know? And she's going to talk about the data and how people can know that. So the witness says it's very easy for someone who doesn't know better to think that the time that the window where the search was made was open, that was in fact the time the search was made. But she says, no, those are two different things. And the time that the defense witness initially thought he had an aha moment, she says, that wasn't really an aha moment. He just was making a mistake. It was when the window was open. He thought it was when the search was made. He was wrong. And the witness says, yeah, untrained examiners, which would be a dig at the defense expert, would make this kind of mistake. So here's what she had to say.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, how long to die in the cold, and seeing the 2:27 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 2:27 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded, or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning.
So then the plot thickens because Celebrite, which is the company that made the digital extraction program that all of these experts were using, changed its program because they said, yeah, we've realized that the time that the window was open might confuse people. So they changed the way that the data is presented so that people don't make what they call a mistake like they have made in the past. That's what Ian Whiffen from Celebrite was supposed to testify to. He did testify to that, but he also testified to a whole bunch of extra stuff. And that extra stuff, frankly, was really a problem for the Commonwealth because he got slammed on all of that. Whereas this one easy point that he had to make got a little bit lost because he got slammed in some other things that he had been, not being a professional expert witness, had maybe made some mistakes. So now there's more than one program that can do this digital forensic extraction, not just Celebrite. There's also one called Axiom. This witness, in fact, used to work for Axiom. She was a director at Axiom. So This witness admitted that Axiom still shows that time, but she says there is a difference because Axiom warns people not to make the mistake that the Celebrite folks were making.
You mentioned that Celebrite showed the search on the report as How's Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Okay, now for those of you who are really confused by now, I'll be honest, that's kind of how it works in the courtroom as well. When the expert comes and says something pretty much incomprehensible to lay people, and then another expert comes and says just the opposite, equally incomprehensible to the layperson. It's frankly a problem in our court system right now. It is very difficult for people to understand it. I believe what she's saying is that when you open up a window in your phone, Celebrite marks a time, at least the old program before they fixed it. Axiom still marks that. And if you keep that window open and you keep changing the search bar, but you never close that initial search window, then everything is marked, whatever your last search is marked as when the window opened, not when you did the search. And people could get that confused, but it is somewhat mystifying. And I'm sure the jury is also pretty confused about this. I have absolutely no doubt about that. Let's add her back in. Give it just a second. It's switching between.
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "How's Long to Die in Cold" was searched at that timestamp tab of 227:40?
Yes, I came to an opinion.
And what is your opinion? Now I want.
Okay, now I want to talk about this because the judge made a statement that really got the defense heated, apparently. We didn't see it. It happened at sidebar, but what we did see was the judge apologize. Now, this is unheard of in a courtroom, but here's what happened, I think. The judge is about to make a comment. Let's go ahead and hear what happens.
To ask you to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's Long to Die in Cold" was made at the time of the timestamp 227:40?
It's the last time Mr. Massey on this issue, okay?
Sorry, it's so fast. I mean always to slow it down, but I'm usually listening to it pretty fast. So, okay, here's what happened. This witness, they really wanted to keep this information out. The defense wanted to keep this testimony out. So before it came in, they kept objecting to it. That is exactly what they're supposed to do. And you're going to hear the judge say that in just a minute. Yeah, that's their job. So Leslie would say, we have a sidebar, and he would argue. And I think 3 times the judge had the prosecution, the Commonwealth, Hank Brennan, go back and lay a little bit more foundation. You aren't quite there. Do a little bit more. Had him go back and do that 2 or 3 times. So now here is yet another objection from Alessi after all this foundation has been laid. And she's like, okay, last time, Mr. Alessi. Okay, last time. And shockingly, the judge then apologized for that. And that was pretty shocking. What she said was, I'm sorry, just want you to know that the lawyers are doing their job, and so you should pay no attention to anything I say regarding that. That's never mind. And I thought pretty impressive that she did say that. I thought that was really helpful. Now, this witness also said that there was a lot of other data, not just the mistake about when the window was open, but there was other data that suggested that the search was done at 6:24 and not at 2:27. Now, know this, we are going to hear lots of argument on the other side when Karen Reed gets her chance to present the case. But for now, we're hearing the Commonwealth's case.
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that Hos Long to die in cold was searched at 6:24:18, tracked in that mobile Safari P list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened.
You offered that the how long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that Hos Long to die in cold was searched at approximately 6:24 a.m.
This witness also was responsible for addressing an argument we have heard from the defense. The defense has suggested that this particular search, several searches by Jim McCabe were deleted, that she deleted these searches before she handed her phone over to law enforcement. And they say that's because there were some suspicious searches on there and she didn't want law enforcement to see it. This witness is here to testify to the opposite, that Jim McCabe did not and could not have deleted her searches. Here is what the witness had to say.
To delete a tab, you can open and close a tab, and open and close tabs are tracked in that database. But you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history.
So the cross-examination of this witness by Alessi really was pretty good, but she is a pretty polished witness, remarkably calm. I was really fascinated to watch during the chat on the place where I was watching. It was a big chat. There were thousands of people in this, and it was shocking to me, really. I'll go ahead and pull out. It was shocking to me, first of all, how divided people were, how completely not open to hearing anything that the witness had to say. And it also was shocking to me how rude people were to each other. It made me really appreciate this group. I mean, I keep getting mentions from people that this is an unusually nice group. I am very grateful to y'all for that. It's a very open-minded group. You want to know the truth. You want to hear what's actually happening. I cannot be more appreciative of Marlon and mamapinks, our mods, who help keep it that way, because I can assure you, I have never heard people say things to each other like they were saying in this chat. I mean, there were all kinds of references that were just scandalous that had nothing to do with the case. And it was unimaginable to me. It didn't even make sense. I mean, we're trying to watch the case and understand what both sides have to say, but no one was. People were very much in one camp or the other. So people were either saying, this witness is the best witness ever. Every single word from her mouth is a pearl and a jewel. And look how horrible the cross-examination was. Or they were saying, This cross-examination shows how completely evil and horrible the witness is, and let me make some personal remarks about her. I'm like, oh my gosh, what is everybody doing? Why don't we learn from this witness? So I am very, very grateful that this chat group is like that, because that's a real value for me, and I appreciate that you are like that too. All right, so now the cross-examination, as I said, was pretty good. One of the things he points out is that while Celebrite no longer reports that initial opening time right next to the last search, Axiom does do that with a warning, and Celebrite does still keep the information. Here's what the witness said.
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting. Correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that, and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
So, and two big problems, though, that the defense was really able to make some headway with. An earlier witness, Ian Whiffen, gave the defense some real ammunition that they didn't even have in the last trial when he said he found that John O'Keefe unlocked his phone at 12:27, because that doesn't really fit with the Commonwealth timeline, because Karen Reed arrived home just a few minutes after that, meaning she was traveling sometime around that time. It was only 6 minutes back to John O'Keefe's house, but 6 minutes in the snow, that's kind of a long time. So Whiffen said he found an artifact that suggested that John O'Keefe had unlocked his phone at 12:27, and that to unlock it, it would have to actually be some kind of manual use by John O'Keefe. It wouldn't unlock itself. So this witness refused to confirm that. Obviously, the defense would have liked that. She just said, yeah, I haven't looked at that artifact, that little leftover piece of information. In other words, I can't confirm it. I do think Whiffen is a reputable person. Now, she did make another big error too. And when you've been attacked for hours, it can be a real temptation when you finally get a question that you easily know the answer to, where you're really an expert here, to just talk and talk. And then that's pretty much what she did here. She was asked a very simple question, and she talked a lot about it. It was not anything she was slated to testify about. It wasn't necessary to what she had to say. It was just, so tell us all the ways it would be a really good idea to collect data and from a cell phone. Like, if you were going to collect a cell phone, what would be all the very best ways you would do that? How would you preserve the data on that cell phone? And this is just the beginning.
I'd say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is.
So
and she just went on and on about all the things that should be done. Like, you should put it in airplane mode, and you should put it in a Faraday bag. And these were all things that did not happen in this case. Frankly, they really don't matter here, because, as she pointed out, nothing was deleted. It was vulnerable. It should have been handled differently, yet more of what Mildred was looking at, which is that whole problem of the evidence collection and the failure to do it in a professional and full manner. They didn't. And here's another place where the defense is scoring with the idea that, yeah, the cell phones weren't handled professionally either. Now, the final place, though, where I thought the defense really scored big, again, it's a hit right at the timeline that the Commonwealth wants to present. John O'Keefe's steps were just at the wrong time. Here's what the witness had to say.
got health steps, and it has steps 36, duration 20.9 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
Okay, let's pull that out. Oops, wait, I need to remove that. Okay, so the way Alessi used this, I actually didn't really agree with that. He was using this to impeach her, and it never fully worked. He was trying to say, well, she should have mentioned this, and she's saying, well, I was looking at interactions with the phone, and I don't think of walking as when you're interacting with the phone. It's just kind of passively recording what you're doing. To me, she's saying interacting with the phone is touching it, pushing the buttons, things like that, looking at it if you have a face unlock. But honestly, that's sort of, to me, kind of a who cares? Who really cares about that? Who cares about her using it to impeach her? To me, the far bigger point is that he is supporting the point the defense is trying to make, which is that the steps are going at 12:32. Karen Reed is home within about 4 minutes of this, and it's a 6-minute drive. So how is John walking around? If she hit him, how is he still walking around? How are these movements taking place? Now, we may get some arguments from the Commonwealth on that, but I thought it was a pretty important argument. And that, to me, that was the bigger point of what she was saying from the defense side. Now, we also got another clip. These clips have been devastating for Karen Reed so far. And this one, super short, but I'll play it for you real quick. I think it's 5 seconds or something. It's very quick. Let's hear what it is.
Play clip 15, please.
I told it was Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
So these clips have been used by the Commonwealth to paint a picture of Karen Reed admitting a lot of the things that the Commonwealth is arguing against her. These are statements that Karen Reed made to various news media, because unlike almost any other defendant, she has given a lot of interviews. She's talked to a lot of news media. She's talked to people who are involved in social media who then have talked as well. It's a very different approach to the case. And one of the things that the Commonwealth is doing pretty effectively this time is using little clips of those interviews to where she said something that is potentially helpful to the Commonwealth's case. And they've scattered them throughout the case. It's been very effective. So here was another example of one that was being used today. Okay, so I need to say thank you to a few people. If you and I see a couple of questions over here in the super chats. If you have a question, if you would put question marks at the beginning of your question, it'll help me spot it in the chat. We're going to do a very short little session tonight because we are going on to our members only live right after this. So we still have a lot left to go tonight. All right. So, but let me say, I'm trying to remember exactly where we left off. I'm just going to go back a ways. Oh, I know where we were. John BeatyBot says, won't the morning dash cam clearly show 0624 search? We've seen a fair number of pieces of that body cam, not so much body cam, but we've seen footage from the cars themselves. I think most of the officers didn't have body cam, but at no point have they been able to definitively show us when Jen McCabe got in the back seat with Karen Reed and the two of them were making the search. That hasn't really been shown yet. So we are still waiting for that, if it happens at all. I think they would have already used it if they had it. So maybe it's just not something that they actually have. Dolly pointing out that those TV interviews have been a real tough hit for Karen Reed, and they have been. And has been a member for 8 months. Thank you, Dolly. Anthony Campbell, welcome. Glad to have you as a new member. Don't forget to stick around. We will be doing the live stream afterwards. There will be it's a separate stream, but you will get a link to it if you're a member. You actually may have to go to the page if you don't have notifications on to get that link. You might already be in your inbox if you have the notifications on. All right. Can't think of a better name. Hey, that's not a bad name. I think that's good enough. I'm glad you're a new member. Mr. Wu, I'll allow it. That is the way that Judge Canoni typically rules on an objection. She'll, I don't want such and such to come in. I'll allow it. It is unusual. Most judges say sustain, and she says that sometimes, but she often says, I'll allow it. Marlon pointing out that the mods will share the member link at the end, so you can just link straight over to that. We're trying that. It's a new thing we're trying. Hopefully it will work well for you. Janet Studdard closes out her search windows once a day. Probably a good idea, Janet. Sunset Gazing, thank you so much for gifting 5 Lawyer League memberships. I appreciate that. And there are a couple more over there, but let's get over to some questions. I don't want to spend too long on that. I should have done this a little faster, but we'll start right here at the bottom. And if you put a question mark in earlier, just go ahead and put it in again with the question marks at the beginning, please, please. Okay, so I'm going to start with Emotiva. Don't you think that video will make the jury think that Jennifer McCabe may be a suspect? I think the defense is already going to tell them that, Emotiva. I think that's definitely the argument the defense is making. Jen McCabe, something sketchy about her. She did this search, this hustle on to die in the cold. She's heavily involved in pointing to Karen Reed as a possible suspect. So, yeah, I think they already will be thinking that. So I think the Commonwealth thinks they don't have anything to lose. I think their point is Karen Reed is trying to frame Jen McCabe, more or less, in order to get out of what she did. That's going to be the Commonwealth argument when we get to closing. And couldn't the Alberts have been afraid they would be sued since John O'Keefe was found in their yard? Yes, I completely believe that some of the statements that they made could be interpreted from that light. For example, tell him, he never even came in the house. That was one comment they made. And that definitely could be thinking like, oh, wow, what if people blame us because he was in our front yard? I definitely think that's a possibility, Anne. Connie, do you think the judge has kicked the media out from in front of the courthouse and Karen cannot talk to them anymore? I don't know about that. Interesting. She has been coming out every day from the courthouse and giving a little interview. Her attorneys are not allowed to. They're under a gag order, but she is not. So she's just said a sentence or two when she comes out, just something very brief. So I don't know if the judge has made any changes to that. Julia asking, do you feel the idea of many co-conspirators to frame her in this case seems unlikely? I will tell you, the more conspirators you have, the more difficult it is to make your case, because there are so many pieces running around. The old dead men tell no tales sort of idea that if you want to keep a secret, you better be the only one, because not everybody is going to manage to keep the secret. Someone is going to be a weak link. And in this case, the defense side is having to come up with an awful lot of people who are all in on it, even down to friends of Caitlin Albert who were there at the scene, a paramedic who says she heard Karen Reed say, I hit him. So it is a very sprawling conspiracy, and those are way harder to maintain and they're way harder to prove. Okay. So definitely a good point. I'm looking for question marks at the beginning. Allie M. Do you think it's possible John was not killed instantly and therefore movement may still have been recorded? And in fact, and she says, otherwise we assume death was immediate. Death was not immediate because, in fact, the next morning he still had some vital signs, and they then declared him dead, but he wasn't. When exactly that happened, it wasn't right away. It was a period of time, and so definitely that's a possibility that he was not killed instantly, and that there were some kind of movements there. That's a truly horrible thing to even think about. How many feet from the SUV to the front door? Asked Lily. I don't know exactly. He supposedly moved, I think it was 84 feet. And I don't think it's much further than that from where the SUV probably was. There's a little bit of dispute over that to the front door. In fact, I think it was like 70 something. And then that would give him a few more feet inside. It was something like that. MS thinks Hank Brennan sounds like Humphrey Bogart. Oh, wow. Okay. That could be. Actually, elevate the process. Any thoughts on the ring witnesses' testimony next week, allegedly? So I don't know about that testimony, elevate the process. I've got more to learn, apparently. Voyager, where is the video of Adam tasting green enchiladas? Oh, we do have that. That was our very, it was one of the, I think it was a Friday. It was one of the ones toward the end of the, it was also a Karen Reed video. It was the Friday after the verdict. So what was that, a week and a half ago, I think? It was a Friday. And we have the video of Adam tasting the green chili chicken enchiladas from the Lori Vallow Daybell case. All right. So I'll see if I have anybody else. Oh, yes, I do. I need to. Oh, Annie K has been a member for 14 months, and I agree with you. I really appreciate the mods more than ever after watching what I saw today on that, on the comments on that chat. I was really appalled. I mean, I'm surprised people would say those things at all about anyone ever, much less, some of them. I mean, a lot of people use a fake name, and I think that gives you a little confidence, and maybe people feel like, oh, well, I can say whatever I want. No one will ever trace it back to me, which is, as anyone who follows true crime should know, a really bad way of thinking. Lousy David is a new member. Glad to have you. We'll see you shortly after this. All right, we'll do another question or two. Mello S, do you think, given what came out at the last trial, that the defense will insist on an especially specific jury instruction so decisions are recorded from the jury in real time? I don't think they're going to be able to do it quite exactly that way, but you can bet that last time when they didn't ask for the jury to be polled, everybody there is going to be thinking about this. The judge is going to be thinking about the prosecutor. Nobody wants to walk away from this again and end up with some kind of appellate trouble. So yes, everybody's going to be super careful on how exactly the jury renders its verdict. And they're going to have to sort of massage it at the end as to how is the jury going to let us know if they believe some things are true or believe some counts are false, but can't decide about one. So we'll just see whether they really end up having to deal with that, but they may have to. All right. Well, I will see the members right over in the members only live coming next, and I will see the rest of you on Friday. We will not be live tomorrow night. Tomorrow is the 1 year anniversary of my husband's death. So I will not be going live tomorrow night, but I will see you all on Friday.